This is a panel discussion sponsored by the League of Women Voters of Lake County. On my far right is Jed Stone. And let me get his biography. Jed Stone is a criminal defense lawyer in Waukegan, Illinois. For over 35 years, Jed has defended persons charged with serious crimes. He has earned a nationwide reputation as an outstanding advocate. A fellow of the American Board of Criminal Lawyers, Jed and his firm are also listed in the Bar Register of Preeminent Lawyers. He is listed as a leading lawyer in the areas of criminal defense and appellate law. Jed holds a faculty appointment at Lake Forest College, where he teaches criminal law and procedure. Crane's Chicago Business recently called Jed one of Chicago's most influential lawyers. The Chicago Lawyer has named him a top lawyer in Illinois. Jed has served as a president of the Illinois Association of Criminal Defense Lawyers and chaired the Illinois Coalition to abolish the death penalty. Our second panelist, who we're very happy was willing to come today, is Juan Rivera. Juan Rivera was freed after 19 years behind bars through the efforts of the Center on Wrongful Convictions at Northwestern University. He was freed on January 6, 2012, after the Lake County State's Attorney decided they would not appeal a unanimous Illinois appellate court decision which threw out Rivera's conviction for the 1992 murder in Waukegan. He spent 19 years behind bars. Thank you for coming. And our third panelist is Rob Warden. Rob Warden is the executive director of and an award-winning legal affairs journalist who, as editor and publisher of Chicago Lawyer magazine during the 1980s, exposed more than a score of wrongful convictions in Illinois, including cases in which 6 innocent men had been sentenced to death. Before founding Chicago Lawyer in 1978, Mr. Warden was an investigative reporter, foreign correspondent, and editor at the Chicago Daily News. In 1989, Mr. Warden sold Chicago Lawyer to the Law Bulletin Publishing Company, which has continued to publish it. After that, before co-founding the Center on Wrongful Convictions with Professor Lawrence C. Marshall in 1999, he worked as a political issues consultant, executive officer of the Cook County State's Attorney's Office, and consultant to various law firms and the litigation department of General Electric Medical Systems. He has won more than 50 journalism awards, including the Medill School of Journalism's John Bartlow Martin Award for Public Interest Magazine Journalism, 2 American Civil Liberties Union James McGuire Awards, 5 Peter Lizagore Awards from the Society of Professional Journalists, and a Norval Morris Award from the Illinois Academy of Criminology. In 2003, he was inducted into the Chicago Journalism Hall of Fame. Please welcome your panelists today. All right, thank you. We'll start with Mr. Stone, if that's all right.
Sure.
Thank you.
Prisons are horrible places. Too many people crowded into small, lifeless, drab buildings filled with violence, the smell of sweat and urine, street gangs, insensitivity, dehumanization. They're terrible places. Now imagine how horrible it would be to be there and be innocent. Imagine if you or someone you loved were in a prison for years for a crime you had not committed. We unfortunately don't have to imagine that this could happen. It happens frequently. Northwestern has documented proven false confession cases. A colleague of Rob's, Steve Drizzen, has assembled a list of 6 people acquitted Are these all Illinois cases?
There are many more than 6, but...
6 acquitted, 16 found to be innocent pre-indictment but before trial, 74 found to be innocent pre-conviction.
Those are national figures.
National figures. And 38 post-conviction. Well over 100 documented cases of false confessions. There is a problem. And I don't understand why we as a nation don't take seriously the problem and address it. As I said to someone earlier today, if we were physicians and not lawyers, and I came to a fellow physician, a head of a hospital, and I said, you know, we have an epidemic going on. All of us in that hospital would work together to find the source of the epidemic, the cause for the epidemic, stop the spread of the disease. There wouldn't be any question but that we would all work together. But I find myself curiously, as a lawyer, standing in front of judges and talking to prosecutors about an epidemic of false confessions and not getting the response, let's solve the problem, but getting the response, let's ignore the problem, let's close a deaf ear or a blind eye to the problem. And it is wrong. In Chicago, there is a Chicago police detective who has made a reputation for solving cold cases, homicides. No witnesses, no physical evidence, no forensics, but confessions. 23 of them. 23 confession cases. Now, these cases are unraveling, but 23 men sent to prison on false confession cases. I wish the problem were unique to Chicago, but it is not. Lake County has earned its own reputation for false confession cases. And a handful of detectives are at the core of those cases as well. So, if there's a problem, and surely there is there a solution to the problem? And I think that there is. Why don't we videotape, in the age of electronic media, every confession? Every confession. From beginning to end, not the end result of an interrogation, but the entire interrogation on videotape, so that if there is coercion, that coercion is documented. Why don't we make sure that the interrogator is not a case investigator? Now let's think about that for a minute. Over and over and over again in false confession cases, the police say to the judge, and the judge believes the police officer when he says it, the confessor had information that only a guilty person would know. Well, on first blush, that's fairly damning, isn't it? But then we realize that the interrogator also had that information and could have intentionally or inadvertently given the information that only a guilty person would know to the person making the statement. So let's have the interrogator have no knowledge about the case. How about what happened? What did you do next? Where did you go? What did the room look like? In some of the cases that I've been involved in where we know there were false confessions, An analysis of the confession shows information inconsistent with the facts of the case. I truly had a case in Chicago where a person had confessed and was going to be tried on a homicide, where he confessed to stabbing the victim, and the coroner's report showed that the victim had been shot. This false confession did not last long in a court of law. I've literally had cases where the confessor described a crime that was completely inconsistent with the facts, the immutable, unchangeable facts of the case, the crime scene. And those cases, too, did not result in convictions. The protection, I believe, is to have the interrogator have no knowledge of the facts and have the information taken from the confessor to be the facts from the confessor to the police. I think that is a protection. Add that to doing it on videotape, and I think we've come a long way. But when I've suggested that to police departments and to prosecutors' offices, it has turned on deaf ears. I want to end my comments today by just saying this. I believe that you all know, because you read the media and are involved in your communities, you know that this is a problem. I don't know that I have the solution. I've offered a solution. I am convinced that with 75 bright minds in a room, we can come up with better solutions. We are blessed today by having the two candidates for state's attorney in this room. Chris Kennedy, a Democratic candidate, Mike Neerheim, a Republican candidate for state's attorney. Gentlemen, your charge, whichever one of you wins the election, is to make sure that no innocent person is ever again convicted in Lake County, Illinois. And a way to do that is by making sure that no false confession is ever introduced in a court of law as truth.
Thank you very much, Mr. Stone. Mr. Rivera.
Hi, good afternoon. As you all know, I was recently exonerated for a crime that I did not commit, based solely on a confession that they claimed that I gave them information that was unknown to them. The tactics that Lake County used, this is all based upon what I've read on my trial records, is that only I knew certain information, but they knew it as well. And they have records of that they knew about it. 10 to 11 different detectives for 26 hours interrogated me, accused me, beat me up verbally until they received what they felt was a confession. The Lake County State's Attorney, Michael Waller, stated, "That's not good enough. Go back, get another one." How is it that a person that's supposed to be ethical, that knows the law, state, "That's not good enough. Go back." Beat them up again, not physically that I know of, but mentally. I was 19 years old with a 79% IQ. I didn't know left from right. Thank God today, because of friends that I've gained, have helped me educate myself, better myself as a human being. I can't say that I'm very angry. I'm not that angry, but I am angry. I'm disappointed that I lost half my life. I got stabbed twice in prison because of this case. I had to fight for my food, for my clothes, for my manhood, for almost 12 years. What kind of life should I have now? Should I be peaceful? Should I enjoy life, or should I be bitter for what has been done to me? You know, this is a struggle that I go through every day with my wife, my grandkids. I don't sleep well. I don't trust no one. It's difficult for me to go to a supermarket and buy a soda, because I don't know if people are gonna prejudge me, accuse me, or just verbally just abuse me, not knowing the facts. You know, you are here today to listen to an attorney, a director of the legal bloom at Northwestern that has fought vigorously for me. Since the first day I met him, he believed in my innocence. Unlike a detective in Waukegan that states as soon as he saw me, he knew I was guilty. How can you determine whether a person is guilty or innocent just by looking at them? It's impossible. It's like saying that a color is blue when you can actually see it's green. How do people confess? Simple. All you gotta do is keep beating them up. I had siblings. My parents used to accuse me for doing something that my brother did. Just to get her off my back, I acknowledged it. Yes, I did it. Does that happen today? We know for a fact that it does. This year alone, 11 individuals have been exonerated from prison, either through forced confessions or forensic science, DNA. That's another thing that Lake County refused to accept. DNA exonerated me, still yet, they refused to accept it and believe it. They said that the science is flawed. Well, why did the legal system accept it as fact? I got convicted 3 times, went back to prison, and I still moved forward. I didn't give up. I knew that eventually my time will come. And I thank God, this is my first time in the Lake County area. I'm afraid to come to the Lake County area because I don't know how people would treat me, whether I will get pulled over for no apparent reason, just because my name is Juan Rivera. You know, it's difficult for me to live this way. You know, so I'm just here to express to you, you know, that I am moving forward, okay? I work at Northwestern in the medical research lab. I'm about to attend college. You know, I will not stop living, but I will never forget my past. Thank you.
Thank you. Thank you, Juan. Mr. Warden.
Hi, I'm very happy to be here today. The statistics that Jed gave you about false confessions are just a little bit out of date. Those are about 5 years old, Jed, but we have newer ones. In fact, we have newer ones for just the state of Illinois. And since 1989, when the first DNA exoneration occurred in this state, in the case of Gary Dotson, there have been 104 documented wrongful convictions. Now, our definition of a wrongful conviction is that someone was restored to the status of legal innocence based on evidence that was not presented at that person's trial. One would qualify by that definition because of the DNA testing that was not available at the time of his first trial. Of those 104, 37 falsely confessed, and those 37 implicated 16 additional co-defendants who also were wrongfully convicted. So here in the state of Illinois, more than half of all documented wrongful convictions have resulted from false confessions. That's clearly a very serious problem. Now, we have taken some steps. The General Assembly in 2003 enacted a statute requiring the electronic recording of the entire custodial interrogation. I think that would end a lot of abuses and probably would have saved Juan Rivera from conviction had that law been in place at the time. The idea that Jed Stone has advanced of having a person conduct the interrogation who is not familiar with the facts of the crime, hasn't been involved in the investigation is, I think, probably a pretty good idea. But I think an even better idea is to eliminate, to limit the lengths of interrogations to no more than 4 hours. Our research has shown that accurate interrogations accurate confessions, truthful confessions, appear to come relatively quickly, and false confessions often span long periods of time. One interrogation session to which Juan was subjected was off and on for 23 hours, which is just really, really an incredible amount of pressure. Now, of all of the elements, all of the factors that we have seen in wrongful convictions, I think that false confessions are probably the most difficult to comprehend. You can't imagine that you would ever confess to a crime you didn't commit. I can't imagine that I would either. But in fact, we know, the statistics show us, that this is a rather common phenomenon. Now, how does it happen? Well, it happens in a number of ways. A principal way is to literally brainwash the individual. Sometimes the tactic goes something like this. Okay, look, Joe, you know, we know you did it. There's no question about it. We found the murder weapon in your room. There was blood on your shirt. It's the blood type of the victim. The evidence that we have is absolutely overwhelming. You did this crime. Now, we believe you when you say that you can't remember it, but when a good person like you, a person with no criminal record, nobody who's been in trouble before, does something like this, there is a common phenomena, a sort of a self-protective amnesia in which you can blot it out of your mind and out of your memory. So we believe you. We know you did it. There's no question about that. But you can't remember it. Now, we're not going to be able to help you until you start remembering. That's what we're here for, to help you. And before long, you get somebody speculating about how he or she might have committed the crime. Now, that is a brainwashing technique that we have seen over and over and over again, and it doesn't happen just to people who are young or have below average intelligence. One false confessor in Virginia had a master's degree and worked in the patent department of R.J. Reynolds Tobacco Company. She was clearly a well-educated person, and yet she falsely confessed and actually went so far as to go out and deconstruct her alibi. That woman's name was Beverly Monroe, and a police officer just got it through his head that her boyfriend had been murdered. It appears that he had killed himself, but this police officer didn't think that. She'd been with him the night before, and after weeks of interrogation off and on, she wasn't in custody, he persuaded her that she had witnessed this crime, that she had witnessed this event, and blocked it out of her mind, the phenomena that I just mentioned. She became convinced that that was true, and she said, oh yes, okay, now I'm beginning to recall. I was there, it was just absolutely horrible. I said, aha, you were there, but guess what? This was not a suicide, it was a murder. Therefore, you've just confessed to murder. That woman's name was Beverly Monroe, and that's a tactic that we've seen repeatedly. In fact, more competent forensic evidence showed that it was, in fact, a suicide, or at least a very common mode of suicide. In that case, she had, after the night of the death, she'd stopped at a grocery store and for some reason kept the receipt. And very early on during the questioning, she had described going to the grocery store and actually described what she bought and why. then suddenly, after she has finally confessed, she comes up with a receipt, a timed receipt showing specifically that she had purchased those items that she had described months before. There was absolutely no question. And what did the prosecution say about that? They said, oh, people can pick up grocery receipts on the, in the parking lot of a grocery store. Yeah, one that just happens to specify the exact items you said you purchased and have the exact date. You can just go find something like that lying in a grocery store parking lot. That's kind of the absurdity of it. So this brainwashing is one phenomenon. Other times, and I think this may be, well, what happened in Juan's case, is that people have simply been worn down to a point where they will do absolutely anything and say absolutely anything to stop the interrogation, thinking that if I can just sleep, I'll be able to straighten this out. Let's just end this right now. That is, I think, a fairly common phenomena that we see. Then, of course, we have seen a number of cases of physical abuse. Often, the false confessors who we have interviewed have described physical abuse, but they don't often attribute their confessions to that abuse. I remember one young man telling me years ago, he said, oh, they knocked me around a little bit, a couple of body blows here and there, but that's not why I confessed. I confessed because I was scared. I thought I was going to get convicted of a murder I didn't commit. He'd been told that he was eligible for the death penalty because the victim was a 6-year-old boy who had been shot in the doorway of an apartment on the south side of Chicago. That's rather an amazing situation. And some of the false confessions that we have seen are truly stunning. Your Lake County Sheriff's Police came up with a confession of a woman named Colleen Blue who confessed that she had killed her fetus, murdered, given birth, and put the fetus into a dumpster. DNA showed that it was not, in fact, her child, and yet she had confessed to this crime. So it's a very, very serious problem, and we really need to do something to address it. Lake County will be a focus, I think, of efforts in the future because of the high-profile false confessions that have been documented here. The Jerry Hobbs case is a prime example. But it's not confined to just any general locality. It happens everywhere. It happens nationally. As Steve Drizzen and Richard Leo in the article, in the statistics you referred to there, Jed, have shown. And we really need to start taking this phenomena seriously. I thank you very much for an opportunity to explain that.
Thank you very much. Thank you to all of the panelists. Okay, some of the members of the League of Women Voters of Lake County will be circulating with note cards, and we do have some pen and pencils if you need them, and then they will collect them from you and bring them up here. So I don't think it'll take more than a minute or two.
But while we're doing that, if I
Sure.
could just drop 2 footnotes.
Yes.
As I look out at the audience, almost everyone here is old enough to remember the first Persian Gulf War, the war when George Herbert Walker Bush was president. And in that war, American flyers were shot down by Saddam and then paraded in front of television cameras. And these are not young Latinos from the barrio. They're not poor young black men from the south side or west side of Chicago. These are American pilots. And one after the other stood in front of the camera and said, I am a war criminal. George H.W. Bush is a war criminal. This is a crime against innocent people in Iraq. And of course, these were false confessions by some of the young, brightest, best Americans we have. If they'll falsely confess, what would ever make us believe that you or I, under the same pressures, wouldn't also falsely confess? The other footnote I want to drop is that when Rob was describing the brainwashing technique, it must be underscored that when the police officer said there was blood on your shoes, that the DNA on your shirt matched the DNA, that these were all lies, that that's not true. It was a false statement by the interrogator to the interrogated, to the confessor, and that he relied upon the lie as part of the brainwashing to think my case is hopeless. That's the real insidiousness of this. And we don't want to think of our police officers as lying. We want to think of the justice system as being honest and fair. And it's really disconcerting when we learn otherwise.
You know, it is, of course, perfectly legal for the interrogators to lie. The Supreme Court, the U.S. Supreme Court has condoned that practice. We have seen another phenomena. Certainly they probably lied to Juan Rivera. He doesn't remember it, and there's no record of exactly what he said. There's only a written confession that they wrote and he signed. But if you look at this phenomena, it's really a rather incredible thing that they can lie to you, but in his case, they not only lied to him in all probability, but then they proceeded to go into court and lie about him by testifying falsely that he had information that only the perpetrator of this crime would have known. Now, unfortunately, the judge in this case, Christopher Stark, barred our team of lawyers from introducing the evidence that showed that these investigators were lying. And Juan was convicted 3 times, despite DNA evidence excluding him as the source of semen recovered from the 11-year-old victim, and despite the fact that he happened to be on electronic home monitoring 2 miles from the crime scene at the precise time that it occurred. And now how could they get around those inconvenient facts? Well, first they suggested that the 11-year-old victim must have been sexually active and she might have had a consensual sexual encounter within 72 hours of the crime, and that explains why the biological material does not match. Now, that so enraged the Illinois Coalition Against Sexual Assault that they filed an amicus brief in Juan's case. And as for the electronic home monitoring, they said sometimes it malfunctioned, but it quite clearly was not malfunctioning in this case. They had no information to indicate that it malfunctioned. He couldn't their only explanation was that somehow he might have slipped out of it, run over, committed this crime, gone back, got back into the bracelet. Totally absurd, absolutely impossible. But the prosecutors led the jury to believe that those were credible explanations for those 2 things. The Illinois Appellate Court for the 2nd District set the record straight, I think, on those issues.
Okay, I'm trying to divide the questions into groups here. I'm going to start with the most number of questions at the moment, and we're going to try. I think we're planning to get to all your questions, so don't worry. A lot having to do with police behavior, and so and that they are addressed to all of you. I'll read a few because they're similar. To the panels, one person wrote that sometimes they'll say, the police will say, I presume, we will go easy on you if you tell us the, quote, truth. Once you are beaten by police, the system has to find you guilty to cover their charges. The other question in that vein, why are law enforcement officials not made more personally responsible for their bad behavior? Why aren't they required to have liability insurance? Because the taxpayer is paying for the incarcerated individual. I'll start with those two, and then I have others along that vein. To anybody?
Well, there are a number of reasons. First, the individual officers are indemnified for compensatory damages by the jurisdiction for which they work. In Juan's case, that would be the city of Waukegan and the county of Lake. You cannot sue, of course, prosecutors. You can only sue the police for deprivation of your civil rights. And the officers are hardly ever held individually liable in those cases. They could be held liable for punitive damages, but the problem is police officers are not wealthy people. They don't have a deep pocket. In a recent case in the city of Chicago, the attorneys, after getting a humongous verdict against police officers, agreed to forego punitive damages just in exchange for an apology from the police, which was immediately forthcoming. But that's why that police officers are never held, are usually not held personally responsible for this. Jed?
There have been big awards, though, haven't there? There have been big awards, haven't there, against states and communities that have had to pay to indemnify?
But those judgments are generally against the municipalities.
Okay.
And even if they're against an individual police officer, the municipality indemnifies or pays for the misconduct. I think there was a second part of your question, though, and I don't remember it.
There were two. Why are they? Well, you know, there's another angle besides the cost. It says, why are law enforcement officials not made more personally responsible for their bad behavior? That could be more than just money when you're making someone personally responsible.
This is what I mean when I say there is an epidemic, and if we were physicians, I promise you that if there was some procedure within a hospital that was infecting the patients in the hospital, we would all work together to stop that procedure. We'd learn to wash hands after every examination. And if a physician or a nurse did not wash his or her hands, she would be reminded or disciplined to do it. But somehow, in an adversarial world of law, when I call to the judge's attention that there is an epidemic and invite him to work with me to find a solution for the problem, I'm seen as an obstructor, as someone who's in the way of justice. And that's very, very disconcerting. I remember vividly a case of a young Polish immigrant, 19-year-old boy, Wojtek Dembski, who was charged with a murder in Chicago that he absolutely did not commit. And what a Chicago police officer had done in that case is taken Wojtek's statement about a fight that he had gotten into with a construction worker and superimposed that confession to the fight with a construction worker onto an unsolved cold case murder of an old man who was at a bus stop on his way to work. And it was that superimposition of facts that we clearly showed to the judge in pretrial motions. I went to the state's attorney's office and I said to the first assistant state's attorney in Cook County, these are the facts. Please drop this prosecution. And Jim McKay said to me, oh, Jed, you're a good lawyer. You'll probably win this case. Don't worry. That's somehow not the issue. That was not the point. And I said to Judge Fiala, this is a problem. You need to do something about this problem. Step back, Mr. Stone. Sit down, Mr. Stone. We'll pick a jury and let the jury decide this question. Now, Wojtek is fine. He had the luck of a good outcome. But he could have just as easily been down the hall from Juan Rivera and still in prison because, oh, you're a good lawyer, everything will be fine. I don't believe it. I believe I work in a septic system. I believe that I work in a septic courthouse. I believe that my opponents are in a septic state's attorney's office, and unless we solve this problem together, the disease will kill us all.
Thank you. And I think what you did, was elaborate on that other question where the person said the system has to find you guilty once they've already gone so far in their tactics. And that's pretty much what you were describing there. It's once committed to a road, there's a reluctance to stop and admit that there's a problem.
It's human nature not to, I'm told that it's human nature. I'm told that it's human nature not to admit that you've made a mistake. I don't know. I'm married. I admit to making a mistake every day. Geez, I was wrong. I'm sorry. But I'm told that it's human. Why can't prosecutors admit that they made a mistake? Now, permit me this story. I was one of a series of lawyers that represented a fellow by the name of Rolando Cruz. You may have heard of him. The case is also known as the Nicaraco case in DuPage County. And a series of prosecutors prosecuted Rolando, sent him to death row, and he was innocent. In that case, as I stood back and watched that case unfold, I think I came up to know why it is that it's hard for prosecutors to admit mistakes. Janine Nicaraco, a child, was abducted from her home, raped and murdered and left dead on a prairie path in DuPage County. A fellow by the name of Brian Dugan committed that crime. And had they conducted an investigation, within days of the crime, they said that the crime had been committed by a gang of Hispanic burglars, which always confused me because why assume that it was done by a gang of anybody? Why assume that the gang were Hispanic? And why assume that there were burglars when nothing other than a child and a blanket were taken from the house? Not a stereo, not a silver tray, not a television set, just a child and a blanket. But the state's attorney said it was a gang of Hispanic burglars, and so Rolando Cruz and Alejandro Hernandez were prosecuted. About a year after Janine Nicaraco's death, a woman was raped and murdered in Kane County. Her name was Donna Schnorr. About a year after that, a child was raped and murdered, was attacked in a neighboring county and ran away and got the license plate number of Brian Dugan's car. And it was from that Brian Dugan was arrested, and from that Brian Dugan told Ed Sizowski, a really wonderful commander of the Illinois State Police, one of the greatest cops I've ever met, a guy that's so much a cop that he's ended every conversation I ever had with him on the phone by saying 10-4. It is from Sizowski's conversations with Brian Dugan that we learned that Brian Dugan killed Donna Schnorr and Brian Dugan killed Janine Nicaraco. And maybe the reason the state's attorney couldn't ever say, we made a mistake, is because he couldn't face Donna Schnorr's parents and say, if we'd done our job in the Nicarico case, your daughter might be alive today. And I understand that. But man, this is tough work that we do. Criminal justice is hard. It's gut-wrenching. And sometimes we have to look and say, we made a mistake. We are sorry. But that sorry is far better from the injustice that will result if we don't.
Thank you.
I'd like to add just a footnote on
certainly.
the Cruz case. After the second conviction, in which you were involved in that trial, an assistant attorney general named Mary Bridget Kenney did something that I think that we came to regard as absolutely heroic. She went to her supervisors and said, I can't in good conscience respond to the appeal in this case. This man, Rolando Cruz, obviously is innocent. What did her superior suggest that she do? Write a weak brief and hope for the best. That's it. Mary Bridget couldn't accept that and resigned from the Attorney General's office. But, you know, that's the kind of thing that you wonder, why should Mary Bridget Kenney be considered a hero? She did what we ought to expect of every single public official. The right thing. We seldom get the right thing from prosecutors, as unfortunately I think Lake County has shown us very dramatically in recent years.
Thank you. Well, that kind of ties in with this question when you're talking about the wide breadth of the number of people that are involved in this process, for good or for ill. How much do you think it's a result of the conduct of particular people, officers, and how much is the way the system is set up? For example, the fact that police can lie. Are there other reforms of a kind of a wide-ranging basis that you can see might be useful, or specific? Well, let me tie this in here. Specific, like I'm thinking, this is me here, like a statewide standard evaluation of police. For example, this person is asking, is there any accountability? And a certain detective is mentioned, who I think was the one that interviewed you, Mr. Rivera. And it says, why is he now being encouraged to go and train other detectives? So, is that the right person? I think, yeah. So, all these steps, are there reforms that could be broadly applied?
I just am thinking, I don't know the detectives in Alexander County, Illinois. I don't know. That's down at the bottom of the state for those of you who are geographically interested. I don't know who they are. So I can't judge anything about a detective from downstate. But boy, do I know the detectives in Waukegan. I do. And I know who is a truth teller, and I know who I wouldn't buy a car from. And so do the prosecutors. They know who is a truth teller and who is a liar. I am told that there was in the state's attorney's office a secret memorandum, one that I never saw, naming a specific detective and saying, watch out for this guy. How come I never heard about that? How come you never showed me that memo, Mr. Waller? How come I was in the dark that you all suspected he was a liar, but you never showed the memo to me? Am I not allowed to know that you don't trust one of your own witnesses? And if you know something about his believability, A, why don't you tell me about it? And B, what are you putting him on the witness stand for? And why are you tolerating him drawing a paycheck on public dole? Why? Why are you doing that? I don't get it. I believe that the state's attorney's office in Lake County can identify five cops that should not be trusted. So let's out them. What are we protecting them for? And I agree. Why are they going around the country teaching people how to take confessions? It just is goofy.
Just on a historic note, the interrogation techniques are taught in police academies. Police officers take courses that are presented by various organizations, the most prominent of which is John Reed and Associates. These techniques were invented by, I'm sorry to say, a Northwestern University law professor, the late Fred Inbow, who I happen to know quite well. Fred had, of course, no desire to come up with techniques that would get innocent people to confess. That was the furthest thing from his mind. What he wanted to come up with were techniques that would get the guilty to give it up. And he and John Reed did come up with such techniques. Unfortunately, they work so well on the guilty that they also sometimes work on the innocent. And that's a real tragedy. Now, many of the false confessions that we have seen, I'm convinced, were really resulted from officers who were acting in good faith. Not true of Juan's case, not true of Jerry Hobbs's case, not true in general, I think, of Lake County. But in others, and I think the majority of them, the officers were acting in bad faith. They were just following bad procedures. And those are what we really need to correct.
Well, this question says, what accountability is there when police officers or detectives knowingly lie about an arrest or a charge? I mean, is there anything that can be done?
As of this moment, I think we live in a world that is very forgiving of police officers who are doing their job. I think that it is not incorrect to suggest that the police have a difficult job and stand as a blue line, if you will, to borrow a phrase, of protection between bad guys and us. I think that's generally believed, and I think that there is truth to that. So I think that, I mean, I've tried many, many criminal cases and dozens of civil rights cases against police officers. And I find that jurors are very forgiving of a police officer who is doing his job. Even when they are wrong, sometimes even when they are corrupt, if they are doing their job. They're very unforgiving of police officers who steal, who deal drugs, but police officers who are doing their job, I think, are by and large given a blind eye and a deaf ear when we say it was a coerced confession or it was a false confession. I don't believe that there is there has been a climate for finding them responsible. On the other hand, I must say that when the New York Times runs a Sunday magazine article about the Lake County State's Attorney's Office, people take notice. When the Chicago Tribune puts these cases on the front page, above the headline, people take notice. And I'm getting a sense, when we have Sunday afternoon forums where you could be out in your gardens this afternoon, but instead come to talk about false confessions, where we have both major candidates from the Republican and the Democratic Party in a room talking about false confessions, I think that there is hope that this climate is changing. I think the solution to the problem is not difficult. Mr. Kennedy, Mr. Nierheim, I want each of you to say when you are elected state's attorney, not on my watch, We're not going to have cops coming to court and lying on my watch. And when you leave the state's attorney's office and become judges, as so many do, we have to stand up when you enter the room, and you wear a black dress to work. I want you to say in your courtrooms, not in my courtroom, we're not going to allow that in my courtroom. Mike Dukakis, you may remember him, ran for president many years ago and had said something that I loved. Said many things I loved, but I was in the minority. But one of the things that he said that I loved was, the fish rots from the head down. I believe that. And so, if the judge says, this isn't going to happen in my courtroom, and the prosecutor says, I'm not going to tolerate this under my watch, and the chief of police says, we're not going to permit a cop like that working for me, and the mayor says, not in my town we're not going to have cops like that, then maybe, just maybe, they'll join me in fighting this epidemic and we'll find a cure.
Thank you. Since you did mention State's Attorney Waller specifically, this question also asks whether State's Attorney Waller has been, is he going to avoid any responsibility for some of the wrongs that have happened on his watch?
Yes.
Mike's retiring, and like so many that retire, he will enjoy gardening and golf and Bulls basketball. Yes.
You see, unfortunately, well, in this country we have what's known as the doctrine of sovereign immunity. We borrowed this from England. It basically means you can't sue the sovereign except under the conditions that the sovereign has given you permission to sue. Now, you can sue police officers under the Civil Rights Act of 1865 for violations of your civil rights, but you cannot sue a prosecutor unless he has moved outside of his role of prosecuting the case and become an investigator. I believe that may be the case in Juan Rivera's case, and there may be a case against Waller for his role in sending investigators back to get a better confession because the first one wasn't good enough.
Okay, thank you. Here are a couple of questions having to do with taping of interviews. The first one says, should the taping be audio only or video? Did you say that there is taping of confessions now? Is that true of all confessions? And then this other person says, do you think detectives will be able to use tape statements to their own advantage?
Oh, yeah. I think that, that taping, well, first of all, the first part of the question, obviously video recording is preferable to audio recording. The only reason that we have the term electronic recording is that some downstate sheriffs came in and said, a video camera would be too expensive for us. And, well, you could run over to the Walgreens and get a tape recorder, couldn't you? And so the legislature, accommodating that, said that you could just simply tape record the entire custodial interrogation. And it's presumptively inadmissible in court if it is not done. That's a rebuttable presumption that could be overcome under certain circumstances. If you could show, for instance, that the guy said, look, I want to confess, I just don't want to do it on tape. You could probably get that in if you could prove that.
Rob, this is only in first-degree murder cases.
Oh, yeah, it's only in first-degree murder cases.
It's not in rape
well,
cases.
It's in murder cases.
Not in involuntary manslaughter cases, not in burglary cases. So it's limited.
Except, of course, it's probably done in most involuntary manslaughter cases because at the time the investigators, the police are investigating this crime, they're not sure whether it's going to be a murder or a... It's kind of funny when we were working on that in the legislature, it was sort of amusing. A couple of legislators suggested, well, what if we just applied this to capital cases? And we said, well, that'd be just fine. because the police obviously don't know whether it's a capital case at the time they're conducting the interrogation. And finally, the legislature got that and took that out of that law. You know, there's another problem, that confession, the only standard for admission of a confession in court is that the confession be voluntary. The police officer comes in and says, you know, he just broke down, hung his head, said he was very sorry, and blurted out the confession. Entirely voluntary. The guy tells a different story, but who does the judge believe? But the only standard for admission is a judicial finding that the confession was voluntary. I think that standard should be changed, and it ought not be merely the question of whether it is voluntary, but is it reliable, which is which would be a much more important standard. This electronic recording, by the way, and we're talking about entire custodial interrogations from the giving of the Miranda warning until the conclusion. This has been voluntarily adopted by many police departments around the country. It has been done under court order for a number of years in both Alaska and Minnesota. Illinois has the best law that makes any confession presumptively inadmissible. 7 other states now have laws patterned after ours, and then we have all of these police departments who are doing it voluntarily. Now, why would a police department want to do that voluntarily? Because it protects them. It stops frivolous motions to suppress, false accusations that the suspect was abused, or it does all of these things. It saves court time, it saves officers time in testifying, prevents frivolous motions, leads to pleas in cases that otherwise would go to trial and be appealed, saving the taxpayers' money. In other words, this is something everybody wins. And yet we saw in Lake County, after the enactment of our law, Lake County Major Crimes Task Force had the electronic equipment, the video equipment available before the interrogation of Jerry Hobbs. Could have used it. The law didn't require it yet. So what did they decide to do? Don't use it. And you saw the result. And I think that, you know, it's so amazing now that, you know, St. Paul Insurance Company, which is insuring major jurisdictions in Lake County, has filed for a declaratory judgment asking to not be liable for judgments in these cases because they, in fact, are intentional torts. So this may wind up costing the taxpayers of Lake County a lot of money.
Thank you. Here's a question. Why not just ask for a lawyer and stop the interrogation?
I myself, when I went to John Reed & Associates, when I took 2 polygraph tests, which I passed, I was still interrogated. They still beat me up, telling me that you did it. Don't lie to us, we know you did it. I tried to walk out the room, couldn't do that. I asked for an attorney, but who's gonna believe me compared to 2 cops and an investigator? It's my words, criminal, compared to officials. So, yeah, we could ask for an attorney, but as they said, let's just record it. They don't believe us because we're the ones that they're arresting for this alleged crime. So, it doesn't work.
All right, well, I'm glad that I have a few questions for Juan now. There are a few on this card here. Were you given Miranda warning? Were you represented by counsel, which you started to answer there? Prior to your false confession, was counsel appointed, and by whom? And was he competent in criminal law?
Was I given Miranda warnings at the very beginning? Yes. They gave me a paper to sign. Of course, I know what Miranda warnings mean now. At that time, it's just a piece of paper. Sign it so we could take you upstairs and ask you some questions, which, of course, being naive, I did. Did I have attorney representation? No. not until after I was being indicted. When the public defender's office, his name is Henry Lazaro, was appointed to represent me as my attorney. And all he asked me to say was plead the Fifth Amendment, because I don't know what's happening either. So if he don't know, being an attorney of the Lake County area, what do I know? So I didn't have no representation until after, and as you know the results, I was found guilty of this crime.
I know you talked about this a little bit earlier, but this person is concerned about your life now and hoping that you're able to enjoy family, friends, and society. Welcome back.
Thank you.
Okay. Something on DNA. Since the advent of DNA testing, let's see, are there too many incarcerated persons to test every piece of evidence held that could exonerate? Oh, so it's about the overload in the number of cases. How many untested cases do you think there are?
I am a two-lawyer office in Waukegan, Illinois. Hardly, New York City, city of Chicago. I'm what you would call a tiny suburban law firm. My tiny suburban law firm has had 5 DNA exonerations. If we've experienced 5 cases of wrongful convictions with DNA, as a tiny little, I love myself, I think I'm a good lawyer, but let's face it, I'm just a 2-lawyer shop in a little town. If we've experienced 5, there have to be hundreds and hundreds. And of course, it would take someone to take a look at those cases. Nobody's going to do it. I don't expect the courts to do it. The law loves finality a lot more than it loves justice. I'm told all the time, this case is closed. Sorry, Jed, you've got no standing in court. This case is closed. Call the next case. I don't think there's I think there is a huge problem. I think DNA is a potential solution. I also want to say this. Many years ago, a very smart lawyer reminded me that violins don't play music. That a violin in my hands doesn't sound the least bit musical. The violin in, the hands of a concert violinist makes beautiful sounds. DNA is only as good as the technician who's running the test, and sometimes only as good as the lawyer challenging the technician running the test, and sometimes only as good as the lawyer who has experience, knowledge, and expertise to know how to challenge the expert technician who ran the test. And so the mere fact that there's DNA evidence today, I don't think is the answer. I have a case now where there is a claim that DNA is found on a gun. It is a mixture of DNA that is such that they cannot eliminate my client as participating in the mixture of DNA. That hardly sounds like proof beyond a reasonable doubt, but it's pretty compelling testimony. We're going to have to get the lab notes of that DNA technician. We're going to have to analyze the work that she did. Was her bench contaminated? How did she do it? What was the evidence that she found? What were the alleles that she found? How do those, and then show all of that work to some expert who can then educate me into how to cross-examine her. Another good lawyer told me years ago, be a fact skeptic and a rule skeptic. And I think those are good, that's good advice to a criminal defense lawyer. I don't believe anything, I don't trust anything until I put it through a careful analysis. And it may be that when we look at the DNA in this case, I will have a very heartfelt conversation with my client and say, let's work a plea. Because it may be his DNA on that gun. But it also may not be his DNA on that gun. And there may be 100 things that we can do at trial. And I hope I'm good enough to do 50 of them. And that's my answer to the DNA question. Yes, it's a powerful tool both for innocence and for prosecution. But it is not in and of itself an answer.
I agree with everything you said, but I would add that here in the state of Illinois there is some good news, and that is that the Illinois State Police Crime Laboratory has really become a pretty first-class operation in recent years. It wasn't always so. This is a crime lab that basically sat on its hands in the 1950s while a man named Lloyd Eldon Miller was convicted and sentenced to death for the murder of a little girl based on the blood on his shorts that turned out to be red paint. So we have a really bad history in this state, beginning with that case. It's a fairly famous U.S. Supreme Court case known as what's his name? Eldon Miller. Miller versus Pape. Miller versus Pape. Is that right, Jed? But it has improved. Now, since the mid-90s, DNA testing, if available, in a sexual assault case has been done prior to trial. And therefore, many of what would have been wrongful convictions have been weeded out, and we're not going to see those. In fact, I think at some point, the era of the post-conviction DNA exoneration is going to come to an end because all DNA testing is going to be done before trial. But now, if you want to think of something, in 1996, the U.S. Justice Department came out with a report, this was under Janet Reno, entitled Convicted by Juries, Exonerated by Science, going through all of the DNA exonerations to that time. There weren't that many, but there were a handful, maybe a dozen. And a footnote in that report said that the FBI, which had begun doing DNA testing for local police departments across the nation, had excluded 26% of the samples presented to them as not being involved in the crime. Now that's a pretty amazing thing when you think about it, because these are sexual assault cases. The vast majority of sexual assaults are dependent, and it's sufficient to convict, solely an eyewitness identification. The witness's testimony alone is sufficient to sustain a conviction. So how many of these people had been identified by the victim or led to identify the victim, and then 26% of them are excluded? That's pretty amazing. Now, we've tried to get follow-up statistics on that, and the FBI won't release them, believe it or not. But DNA testing is now being done prior to trial in all of those cases. Now, in the 250 nationwide DNA exonerations that we have, all of those, 100% of them involve sexual assault. There were some murders, I think about 40 were murder cases, and the rest were straight sexual assaults. Now, so it's shown that we have this problem in sexual assault cases, and these cases were dependent upon eyewitness identification. So we know that eyewitness identification is pretty bad evidence, not reliable, and if it's not reliable in sexual assault cases, how bad must it be in armed robbery cases, where a victim has just literally seconds sometimes to see the perpetrator, and tends to focus on a weapon if there's a gun involved in the case. How bad is that evidence? Well, you know, we've now begun to see, and police in this state have fought reform of eyewitness identification procedures, but the bad news is that even if, and there's just been a field study done in Minnesota of what's called the sequential double-blind system that is believed to greatly reduce erroneous eyewitness identifications as a result of faulty lineup procedures. And this study has found that even with best practices employed, fully a third of eyewitness identifications of strangers are false. And yet our law permits a conviction based solely on an eyewitness identification. Should that change?
One of the most dramatic moments of a criminal trial is played out when the witness is on the witness stand and the prosecutor says, "And do you see that man anywhere in the courtroom today?" "Yes, I do." "Could you point him out and identify an article of clothing that he's wearing?" It's the young man sitting to the left of Mr. Stone at the defense table wearing the blue shirt. It's the only African American in the courtroom. It's the only guy sitting next to me at the defense table. It's, you could walk into any courtroom in America and know nothing about the case and say, "Could you figure out who the defendant is?" "Yeah, it's the guy sitting next to the defense lawyer at the defense table." So this thing that's a heightened moment of great drama in a courtroom is really an exercise in, and I agree, there are problems with identification. Earl Stanley Garner, the guy who wrote all the Perry Mason books, I love Perry, he never lost a case. I'm jealous. He wrote famously, "Eyewitness identification of strangers is untrustworthy." And I believe that to be true. Now, it's a problem.
Okay, thank you. A little break in the procedure. I do have a card here, and I would like to hear, if you don't mind, from a gentleman who says, "I would like to tell you about my daughter, Melissa Kalasinski, and what police did to her." Mr. Kalasinski, are you here and you wanted to say a few words? Okay, did you want to? Want me to come up there? If you wish, are you able?
Recently, my daughter was convicted of a crime in Lake County as recently as just a few months ago. She got 31 years for a crime she didn't do. These gentlemen up here and Mr. Rivera are all talking about everything that I seen in my daughter's tapes and how she was coerced into a confession. The way that the police officers explained it during her 4th and 5th Amendment hearing that they had, they said it's a theme. What they do is they come into a room, they read them their rights, they say that it's normal for them to read them their rights during the time. After that, they do that, then they come up with 5 different stories. When they turn around and they tell you that her story has changed 4 different times. That's what they said in the news from the very beginning of her crime. But into 6 hours of her interrogation, she told the same story. But what they didn't tell you in the news is they used the dead body cadaver of the child which she was accused of killing. They couldn't get it right. They would leave the room. It was cold, freezing. They leave her in a corner. She'd be in a room all by herself. She'd repeat to herself, "I'm not a baby killer. I didn't kill this baby." She even asked for a phone call during the time she never got. They continued to keep doing it. To finally, when they got the 4th story that they wanted out of her, when they called the coroner's office and said, "Stop what you're doing with what you're doing in all the things of the experiments you're doing with the child's body." We got the confession. And this was after 10 hours. But then the next day, they continued to keep interrogating her. They wouldn't stop. And then during the time in the court when I wanted to testify, she said to me, "Daddy, Daddy, I didn't do this. I didn't do it." She was screaming and hollering. I had to get her to calm down. She turned around. She says, "I told them what they wanted me to say, Daddy. I told them what they wanted me to say." And after all of that, they played the tape in the courtroom. Do you know that we were being recorded on the phone and that the audio of my voice and her voice disappeared because you could hear the detective in the background saying, "Tell your father what you did. Tell him how you did it. Tell your dad what you did." The audio was completely gone. Somehow they were able to remove it, but when they turned around and they gave the last 20 minutes of the audio and video to the reporters, when I stood right there, I says, "Why don't you give them all the tapes so they can see how somebody is coerced into a confession?" They refused to get it. They said, "Oh, we can't give you the last. This is all we can give you. We can't give you all the tapes." But the media kept asking for them, but they wouldn't give it to them. So finally, we went into court, and lawyers like yourself, I've seen him at the jail quite a few times, nodded my head and waved and asked me how I was doing. Recently, when we went back in and asked for my daughter's sentence to be recommuted, little behold, we put in what they call as a subpoena on one of the experts. They would not allow us to turn around, you the public, you the lawyers, to see what Dr. Montez, that he indeed flunked his atomic forensic pathology test. It's a test that they have to take in pathology to become a doctor and testify as an expert. He flunked it. So they gave it to the attorney, and Miss Bishop turned around and said, over and over, we don't want this to get out. We want to seal it. So what did they do? They sealed it. They sent it to the appellate court, but our attorney, Mr. DeLuca, and Mr. Cummings were told not to share it with other attorneys. But that doesn't stop me, because this is the first forum I'm coming to. There's another one up on the 21st that I'm going to do in a march in North Chicago. The public needs to be made aware of. And we had a false confession expert in the Fourth and Fifth Amendment that came all the way from the other side of the West Coast to testify at my daughter's hearing and looked at it. And I believe this gentleman here from university knows who he is, Dr. Leo, one of the best ones that there's in the country. And he testified. When we wanted to bring that in, they wouldn't let it happen. And then there was times that Miss Bishop turned around when we would give press conferences. She would make stories up to get me and my lawyers fighting, and then when the lawyer caught on, he didn't listen to her anymore. I mean, he called her in the middle of the night when my daughter did the interview with the Tribune, and wrapping up, with the Tribune, the state's attorney text on a text saying, "Oh, I hear you're having an interview with your daughter and with the news media." The judge came right out and said, finally, if the defendant wants you there, you can be there. It's just all tactics that this county has been using. And winding up in closing, I bowled with a gentleman on Monday nights. His nephew had his neck broken recently. And now this has happened, and he's asked us if we could somehow get him the information about this Dr. Montez, because it seems like this doctor's covering up a lot of things, both in cases, what they're talking about, and then the cases that are pending. So, in wrapping up, I want to thank you for letting me talk, and I appreciate it.
Hope that was all right. All right. Now we have more general questions. You mentioned other states before, Mr. Warden especially, and the question is, how is Illinois doing with wrongful convictions by comparison to other states? And now the question asks number of wrongful convictions and number of exonerations, but I don't think you can count but the exonerations. So do you want to guess on the convictions?
Well, you know, it's pretty hard to say how many there are. You know, usually if we want to know something about our society, we just turn our social scientists loose and they go out and do a survey. If, for instance, you want to know how much unreported rape there is, you just select a sample, you go conduct the interviews, and you ask a simple question: were you raped? And if so, did you report it to the police? And if not, then they report the result, and it has credibility. But we couldn't go into a prison, could we, Juan, and say, all you guys who are innocent, please raise your right hand. I don't think that would have a great deal of credibility. So we really don't know how serious the problem is. In the state of Illinois, however, where we restored the death penalty in 1977 after a temporary hiatus that the Supreme Court imposed in a case called Furman versus Georgia. There were 305 men and women, 5 of the latter, sentenced to death in this state. Now 20 of those, 20 of 305, have been released based on substantial claims of actual innocence and would meet our definition of an exoneration. That is 6%. That's a pretty stunning number. I believe that that number is absolutely realistic when you consider that one of the leading crimes for which people are convicted is armed robbery, and how heavily dependent those are on eyewitness identifications. And in addition, we have something that I think is just absolutely insidious. We allow plea bargaining. Plea bargaining is, it gives you, it's basically an enticement for a person who is guilty to confess to a crime he didn't commit, acknowledge it, and to let a person who is guilty get off easy. And yet prosecutors seem to somehow justify this on the ground that, hey, the system would collapse without it. But what it really boils down to in many cases is, say somebody has been sitting in jail for a year and a half awaiting trial in some kind of a case, and the prosecutor comes and says, look, to your lawyer, if your guy will plead, we'll reduce the charge to X minus Y and recommend a sentence of 5 years. He's eligible for day good time. He's already been in a year and a half. So if he will plead, he can walk out. Now, if he doesn't plead, we can stall around for another couple of months. Who knows how long? We can put this case before a jury, and who knows what the result will be. Maybe your guy will be acquitted, but maybe he'll be convicted, in which case he's going to get 15 years or 20 years or something like that. It is a form of torture. It's an absolute modern form of torture. That's all plea bargaining is. And yet we tolerate it as a society, and we ought not. And we didn't always tolerate it in a time when we had many fewer crimes and many fewer people imprisoned for crimes. But how many people are in prison because they accepted a plea to a crime they didn't commit? Who knows? But there are 2 million people in prison. 3 million people in custody, 2 million of them in prison at any given time. Now, 1% is 20,000, 5%, 100,000. Suffice to say, there are thousands of people in prison for crimes they didn't commit, and I think it's irrefutable.
Thank you. I have another question for you specifically. Mr. Warden, you have worked with Northwestern. Have you ever worked with any forensic psychologists on the Innocence Project?
Forensic psychologists? No.
Or the Innocence Project. How about the
I've worked with the Innocence Project in New York.
Okay.
Yeah, absolutely.
Okay, I don't know what that is. Could you tell us a little bit?
The Innocence Project was founded by Barry Scheck and Peter Neufeld. It does only DNA cases. It has a website. They track DNA exonerations. It's a terrific organization. It was the first so-called Innocence Project in the nation. We were the second or third. It does only DNA cases. We do DNA and non-DNA cases. And as a matter of fact, more than half of our exonerations have come in non-DNA cases.
Okay, thank you. Here's one that might be out of our realm, but perhaps you have some knowledge. What, if any, brain research on how our brains create false memories when we are primed during questioning as a suspect or as a witness is being used?
Richard Offshee is a psychologist. He was at UC Davis, and I'm not sure where he is
Berkeley.
now.
He was at Berkeley, but he's now basically semi-retired, and he's living in London. I just talked to him the other day.
Did a famous study of false memory. I love this story. He interviewed a child and said, why don't you tell me about the time you got your finger caught in that mousetrap? And the child said, what are you talking about? Well, your mother told me that you'd gotten your finger caught in a mousetrap. I said, that never happened to me. A week later, you know, I'd like to hear more about that mousetrap incident. Not only did your mother tell me about it, but your grandmother told me about it. And after the 6th week of interviewing a child about the time he got his finger caught in a mousetrap, an event which never happened, the child tells Dr. Offshee, I was in the basement and I was looking around for something and I reached in and the mousetrap clamped onto my finger and it was so painful, and the child actually cries and experiences pain of an event that never, ever, 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 ever happened. I think that's frighteningly interesting. And there is a great body of work on false memory in the psychology community. And it's very helpful in understanding false memory confessions.
All right. Here's this very specific question. Are you concerned about the trend towards private prisons whereby the owners are paid per cell as they are filled up?
I've had the great privilege of going to Estancia, New Mexico, to visit a client in the Corrections Corporation of America facility. Yes, there are private prisons in the United States. And yes, there is something called the Corrections Corporation of America. It's owned by Bob Barker, the guy who used to do Truth or Consequences on television. And it's an incredible institution. I was there. It didn't look like a prison. I flew to Albuquerque, rented a car, drove out into the desert, and came upon the Estancia Correctional Center, and it was. It didn't look like a prison. There weren't any high walls. There wasn't any concertina wire. It was just out in the middle of nowhere. I walked in, and a very well-appointed young woman in a business suit said, "You must be Mr. Stone." I'm not usually greeted in prisons that way. I said I was, presented some identification. She said, "Mr. Garcia's waiting for you." That's my client. And I went into a room and saw Eric. And at the end of a 2 or 3 hour conversation with my client, I said, what's this joint like? And he said, you know, it's really, really, really weird. You got to buy everything from the prison. Your shoes, Bob Barker. Underwear, Bob Barker. Toothbrush, toothpaste, Bob Barker. He said, but if you were running a prison for profit, Jed, what 2 things would you cut out or cut back on in order to ensure your profit margin? I said, I don't know, Eric, you live here, you tell me. Healthcare, almost non-existent. Not that the Illinois Department of Corrections is the Mayo Clinic, but healthcare in private prisons, almost non-existent. And food, barely edible. Barely edible. I had the privilege of talking to the Congressional Black Caucus in Washington a couple of years ago, and I enjoyed the experience, but I have to tell you that I followed a late Friday afternoon, I spoke late Friday afternoon before the caucus, and I followed a speaker, maybe you've heard of him, his name is Jesse Jackson. You know, in vaudeville they say never follow children or animals. In politics, don't ever be the speaker after Reverend Jackson. He was great. I was okay. But here's what Reverend Jackson said, and he's right. he talked about a cradle to prison pipeline. And the privatization of American prisons has created a cradle to prison pipeline in this country. When I started practicing law in 1975, there were 225,000, let me say that again, 1975, 225,000 men and women in America's prisons and jails. 225,000. Today, as Rob says, over 2 million people in prison. Do you feel safer on the streets, by the way? Have you been reading the front page of the Chicago Tribune? Last weekend, there were 16 shootings in the city. Is the world safer today because we're locking up people? There is a for-profit prison industry in this country, a prison industrial complex, if you will, and it is frightening, frightening.
You know, the prison industrial complex is even, I mean, it's even worse. I mean, we have, first of all, these small communities where we've located the prisons, and then you have prison, so you have political pressure from the local officials and, of course, the voters who are employed by those prisons in those towns. And then you have a prison union, which, of course, is dependent upon, you know, having people in prison for these reasons. And it's just absolutely stunning when you think this political dynamic that has created this prison industrial complex that we can't reverse. And it's absolutely, and the major impact, I think, has been on the African American community. The number of incarcerations. A professor named Michelle Alexander has just written a wonderful book, which I recommend, called The New Jim Crow, which really exposes this. And after reading that book, I started thinking, the first time I ever visited a prison, it was in Jefferson City, Missouri, in about 1967. And I didn't think so much of it at the time. That was the only prison in the state. Now there are 7 or 8. In Illinois, we've got 22 or something, I think. And what are we accomplishing? But when I remember going through that prison, and almost all of the prisoners were white. There were a few blacks. Why did we have this ballooning population? I don't think blacks certainly didn't account for any more than the 15% of the population that blacks account for. Well, I think part of it was that we didn't take our system didn't take black on black crime seriously in those days, and so consequently, the enforcement was handled essentially by the community. In other words, we had anarchy, and we have anarchy to a certain extent, I think, in the Latino community, Hispanic community today. Law enforcement isn't really focusing on the right kinds of crimes. They're just convicting people for the most part, of minor drug offenses to fill up the prisons that the unions and the state politicians are demanding that they keep full. And no, we are not any safer. We are absolutely not any safer today than we would be if we were went back to the 60s. When I came to Chicago in 1965, the Cook County Jail, if you've ever been down there to that complex, and of course the courthouse was just the north half of what it is today, and the Cook County Jail is what is now Division I, and it was behind it. Now you look at this sprawling complex, and most of the people there are Chicagoans. The population has gone down, crime has gone down, and yet we are incarcerating 10 times as many people as we did in the 60s. It makes no sense, and it's costing, I mean, that alone could go a long way toward solving our problem, our budget problems. You know, it costs $25,000 to $50,000 a year, depending on the prison, for each inmate. We could send these kids to Harvard cheaper than we could send them to prison in some cases.
Now, having said that, and having, I feel like we're at a Neil Young concert. You know, we're all getting depressed. Neil Young being a singer who could depress a hyena. But the truth is that I think that there is light at the end of this prison industrial complex tunnel. I think that we will, in the not very far future, see the expenses of the last 40 years as a huge waste of money, And I am fairly convinced that as the conversation begins on the decriminalization of mere possession of narcotics, and certainly the possession of cannabis, prohibition of the modern age, that our prisons will close and doors open for young men convicted of, or charged with nothing more than mere possession of small amounts of narcotics, use only. I see this as, I never thought I'd say the death penalty has come to an end in Illinois. I can now say that, and that has given me confidence to be able to say that, if not in my lifetime, certainly in my children's lifetime, we will see the end of the prison industrial complex. It is a waste of money.
Well, that goes right into this question. What political or social pressures, well, now we can change the question a little bit maybe, are creating an environment for false confessions? And it says, well, what level does the blame lie? Police, state's attorney, we've talked about them quite a bit, but you did mention the juries before. What political and social pressures create this environment, put them in jail, convict them, that kind of thing?
First of all, let me say I love juries. I respect the jury system. Gene Pincham is a dearly departed former judge and a dear friend of mine. And we were on a panel once, and somebody asked a question about bench trial versus jury trial. And Gene said, "Don't trust judges, been one." And I so appreciated his candor. I don't think the problem is with the jury system. The jury system, I believe, works. I remember in a recent traffic case, a jury went out to deliberate at 2 o'clock in the afternoon on a Friday. I had a felony jury out, and at 11 o'clock that Friday night, my jury was returning a verdict, and the traffic jury was still deliberating, still arguing, still trying to sift through the evidence. 12 ordinary citizens taking seriously their obligation. So I don't have a complaint with the jury system. I do think that there are pressures, political pressures, to solve crime, but I think a lot of that is not based upon real feelings of insecurity or safety, because as we know, famously, the crime rates have gone down. There are less homicides in the city of Chicago, well, with the exception of the last 2 months. There were less homicides in the city of Chicago last year than there were 2, 3, 4, 5 years ago. So I asked myself the question, how is it that a wrongful conviction could occur? And for me, the wrongful conviction case, the ultimate wrongful conviction case in my life as a lawyer, is the Rolando Cruz case, the Nicaraco case. And I ask, how is it possible that prosecutors, apparently good and decent people, could knowingly prosecute a person that they knew objectively was not guilty? And the only way I can come up with it is that there is at its core in the criminal justice system, a sense of us and them, the them very often young men of color, Latino, African American, and they are thought of as lesser. They're thought of as expendable. those people are expendable. And whenever you live in a world where there's somebody that's expendable, bad things happen. Jews are expendable. Bad things happen. Blacks are expendable. Bad things happen. Gays are expendable. Bad things happen. And until we live in a world where we see everyone as equal, really equal, until we live in a world where we don't see differences and where there are differences, we celebrate them rather than distrust them, you will have wrongful convictions. In the case of Bernina Mata, a murder case out of one of the western counties in Illinois, Joey Mogul and I were arguing her clemency petition, and we argued to the Illinois Prisoner Review Board that she was given a death sentence, later reversed, because she was lesbian. And the prosecutor argued to the jury that convicted her and sentenced her to death that she was a lesbian and had lesbian books in her library at home. They saw her as different, as expendable. In the famous Scarborough Boys cases, rape cases from the 1930s, the Alabama prosecutor, in response to an objection from a fellow by the name of Leibowitz, the defense attorney, said to the judge, "Well, Judge, we do this in every nigger rape case." They saw those boys as expendable. And so the march goes on. If people are expendable, there will be injustice. If we see people as brothers and sisters, we can avoid injustice. That's the political pressure.
What reform can be made at the state level as opposed to county by county to help prevent false confessions? Have efforts been made in the past? Why were they unsuccessful?
Well, I think we've pretty well addressed that. The electronic recording, limiting the duration of interrogations. I think certainly we should limit the kinds of lies. If we're not going to prevent detectives from lying to people they're interrogating, at least we should restrict the kinds of lies. Kevin Fox was told, and this is a Will County case that I'm sure you've heard about, that his family knew he was guilty and wanted nothing to do with him ever again. And here he is after hours and hours of grueling interrogation and in utter despair. Okay, I did it. I think those kinds of lies about family members, things of that sort, ought to be prohibited. And police ought to voluntarily just ban those kinds of lies. And then, of course, it would be, I think, to limit the duration of interrogations. And then Jed suggested that perhaps interrogations should be conducted by a detective who is not involved in the investigation. I hadn't thought of that before. I don't know. I'd like to think about it a little bit. But those are some of the reforms.
Thank you. All right. And the last question, and I think our timing's pretty good here. What can I or we do to help ensure that these false confessions end?
Well, first thing, when the officer says you have a right to remain silent and you have a right to a lawyer, keep your mouth shut and call Stone. But second of all, we live in a democracy where you have an obligation, I believe, to talk about this. You know, if some idea or issue or problem crept into your mind today, then go home and talk about it. Talk about it over the dinner table with your family. Go to work tomorrow. Talk about it with the people at work. If you go to synagogue or church or mosque, talk about it with the people at your synagogue, church, or mosque. If you keep your ears open to other ideas, share them, and for God's sakes, register to vote, elect public officials, and hold them accountable to running a lawful, just system. And if they don't, send them back to their private law practices and elect someone else. You know, nobody has the right to be the state's attorney of Lake County. It's a privilege. Nobody has a right to be a circuit judge. It's a wonderful job. You know, it's 9 o'clock to 11:30 and then 2 o'clock to about 4 o'clock, 5 days a week. It's a pretty good job. They don't have a right to that job. If you find out that they're turning a blind eye and a deaf ear to injustice, then do something about it. Write letters, hold meetings, do recalls. We live in a democracy where your voice does make a difference. I've said this, I teach at this college and I talk to young people all the time. There aren't any young folk in here today, but I'll say this. I remember in 1965, I went to a meeting, a teach-in against the Vietnam War at University of Michigan in Ann Arbor. There were like 65 people there from all over the country, 65 people. In 1968, what were there? 2 million people protesting against the war? It came from a core of people who said, this is wrong. So we got about 65 people here. You know, if you think this is wrong, let's go do something. You have the power. Or as we like to say in my ute, power to the people.
Can you top that, Mr. Warden?
No, I can't top that. I will not follow Mr. Jackson. I mean, Mr. Stone.
Oh, okay. Well, I feel so privileged to have heard the questions from the audience and to have heard the wonderful answers from Mr. Stone and Mr. Warden, Mr. Rivera. We're so pleased that you came and shared your story with all of us. And to the audience, questions were excellent. And thank you, everybody. Thank you, panel.